Welcome to WG University, Weber Gallagher series of educational programs. This is our employment webinar series. I'm Jennifer Laver and I'm presenting today with Tracy Walsh in our Philadelphia office. If you would like to view this webinar again, share it with others, or see it, go to www.wglaw.com and you'll find copies of the presentation and others under the WG University website. Also, please feel free to contact the firm with any questions at questions@wglaw.com. Today's presentation is substance abuse in the workplace. Today we're going to be looking at the prescription opioid abuse and heroin epidemic. We're going to talk about pre-employment drug screening and the ADA, navigating steps when an employee suspects an employee's addiction problem, and work-related injuries and opioid prescriptions. Everyone currently has heard on the TV, on the news, the government's trying to address the opioid epidemic that's continuing to be a national problem. Right now, the death tolls from overdose of drug deaths continue to rise each year in the United States. It's a problem that has increased attention, and there's currently programs that are being implemented to help stop the epidemic and to cause prevention and try and address these issues. Today, we're going to have Tracy's going to start and talk about the ADA.
Hello. When we talk about the issue of substance abuse or addiction and how it relates to the employment setting, primarily one of the discrimination laws that comes into play is the ADA, or Americans with Disabilities Act. The Americans with Disabilities Act is a federal law, and it does cover private and public employers who have 15 or more employees. In essence, the ADA prohibits discrimination against applicants and employees who are qualified individuals with a disability. And also, there are three ways in which a disability can be defined under the ADA. One is a physical or mental impairment that substantially limits one or more major life activities, a record of such an impairment, or being regarded as or being perceived as having an impairment. A qualified individual with a disability can satisfy the requisite skill, experience, education, and other job-related requirements, and can perform the essential functions of the position with or without a reasonable accommodation. So when it comes to the issue of either of drug abuse or whether it's legal or illegal drug abuse, what we're talking about has to do with individuals who are either recovered drug abusers or individuals who are taking lawfully prescribed medications under the ADA, and we're going to break down and discuss those two different aspects. ADA and the use of drugs. Title I of the ADA states that any employee who is currently engaging in the illegal use of drugs is not considered a qualified individual with a disability who is entitled to protection from discrimination. The statutory definition of the term illegal use of drugs excludes the use of a drug taken under the supervision by a licensed healthcare professional. So the ADA protects from employment discrimination any person who either has been rehabilitated successfully and is no longer engaging in illegal drug use. It does not protect individuals who are currently using illegal drugs. And what is important to keep in mind is that the illegal use of drugs includes unlawful use of prescription drugs.
Tracy, when is an employee not protected by the ADA?
An employee or a job applicant, and it's important to keep in mind that the ADA applies to applicants for positions and not just current employees.
Right.
So employees and job applicants who are currently engaging in the illegal use of drugs are not protected under the ADA. And whether it's casual drug use or it's a drug addiction, does not matter. The pivotal question is whether the individual is currently engaging.
And when is an employer applicant who has used drugs illegally protected by the ADA?
The significant part of that question is the past tense,
Okay.
has used. If an individual has successfully completed supervised drug rehabilitation program and is no longer engaging in the illegal use of drugs, or has otherwise been rehabilitated successfully and is no longer engaging in such use. Currently participating in a rehabilitation program and no longer engaging in the illegal use of drugs, or being erroneously regarded as engaging in illegal use of drugs. So when the employee or applicant is supposed to be protected under the ADA is if he or she has successfully completed a program already in the past before this individual even became an employee, or is currently participating in a rehabilitation program while that individual is either applying to or is currently employed. And keep in mind that, again, under both those scenarios, the individual must no longer be engaging in the current use.
So if they're engaged in the current use, they wouldn't be
They are
covered.
not protected by the ADA. So when the potential issue of drugs may come up for an employer could be at the pre-employment stage before the individual has even been hired.
Okay.
So when it comes to pre-employment drug screening, which is often done by employers, the ADA can and does apply in certain situations, and the EEOC, which enforces the ADA, also takes positions with regard to pre-employment drug screening.
Okay.
The key test is whether the test being administered is considered a medical examination. So if the test is a medical examination, then that means it is protected or is covered by the ADA. If the test is not a medical examination, then it is not governed by the ADA.
Okay. And should you be offering a drug test? Is that something that employers should be doing?
Well, I mean, that certainly is a decision up to each employer as to whether it wants to conduct any sort of drug testing.
And there's different requirements if it's
However, yes, there are different requirements depending
Okay.
on the type of test. So, for example, a test for the current use of illegal drugs is not a medical examination, and therefore it's not covered by the ADA, and therefore it doesn't have to comply with the ADA, which essentially means if an employer seeks to test for illegal drugs, it can do so, as long as it's testing for illegal drugs only. And this is what is often referred to as a 5-panel drug screen. So since the 5-panel or illegal drug test is not a medical exam, it can be conducted before an offer of employment is made.
Okay, so it's important to note that the 5-panel is pre-employment.
Pre-employment and pre-offer, pre-conditional offer as well.
Okay.
And it can only test for illegal drugs.
Okay.
On the other hand, if a test is going to be administered that includes more than the 5-panel illegal drugs, for example, which can call up the lawful prescribed drugs, for example.
Okay.
That test is considered a medical examination under the ADA and is governed by the ADA and must comply with the ADA since it is testing for legal drugs, or in other words, drugs that could be under a prescription. And if such a test is to be conducted that includes more than illegal drugs, that test can only be done, or should only be done, I should say, when or after a conditional offer of employment has been made.
Okay.
So this is an offer where the individual is advised that they're being offered the job, it's conditioned upon, et cetera, et cetera. But as long as that conditional offer has been made, then this test can be done with regard to legal drugs. Also, in that situation, that test should only be administered according to the ADA if the exam or the test is job related and consistent with business necessity.
So can you test anyone, or does it really depend on what job they're doing at the employer?
It will depend on the job relatedness and whether it's consistent with business necessity. That could include, for example, a safety sensitive position.
Okay. So it's important to keep that in mind.
Exactly.
Okay.
So when it comes to the issue of drug testing again, and there are some cases that have been filed by the EEOC throughout the country when it comes to this issue, what the issue is there an underlying disability?
Okay.
And so whether the ADA has been in some way allegedly violated. So, for example, when it comes to the topic of drug testing, there have been cases, for example, where it was alleged that an employer made a job offer to an applicant that was a conditional offer, that a drug test had to be successfully completed. An applicant tests positive for a prohibited substance, and then the employer rescinds the offer. Now, if it's an illegal drug, then it's not protected, so rescinding the offer should not run afoul of the ADA. However, if it was a prescription drug and the applicant has documentation to support the fact that it was legally prescribed, then the employer could run afoul of the ADA if it simply rescinds the offer without having any consideration of that documentation.
So the first step is to determine whether or not there's a positive drug test for an illegal drug, and then if there's a positive drug test for a legal drug, you have to do additional steps.
Correct.
Okay.
There could also be a situation where an applicant is actively involved or participating in a medically supervised drug rehabilitation program. So we talked about when an individual either has already been rehabilitated and is now applying for a position. The potential employer typically wouldn't even know that, or actually shouldn't ask about a past history, according to the ADA. However, there could be situations where an individual may disclose this information voluntarily. So, for example, there was a case filed by the EEOC where the applicant was asked to submit to a pre-employment drug test, and again, no problem with having requested that. However, when the applicant was told that the test would be conducted, the applicant disclosed that she was in a medically supervised methadone treatment, and she was then told that she would not be hired. So the EEOC did file suit with regard to those circumstances, and took the position that the ADA can be violated if an employer refuses to hire a qualified applicant based on fears or stereotypes about an applicant's disability, or just the fact that the individual was in a medically supervised drug rehabilitation program.
Okay.
And as we had already touched upon here, there shouldn't generally be what I would call a knee-jerk reaction to a positive lawful drug test. So, prescription drugs that there may be prescriptions for, and to allow that individual to have the opportunity to present proof that it's lawfully prescribed. And rather than the employer just refusing to hire the individual because there was a positive drug test, there needs to be some interactive type process under the ADA to discuss that. And typically that would be discussed or should be discussed between the MRO or medical review officer and the applicant.
So if they're taking the prescription drug lawfully, then it's something that wouldn't become a problem. But again, there's exceptions if they're not taking it lawfully.
Correct. There could be, for example, the MRO may review the test and determine that the levels that came up on the test were not consistent with the prescription that the applicant presented to the MRO. And again, that dialogue should be conducted between the MRO and the applicant. So in it, obviously we're talking about a pre-employment setting, but once an individual or individuals are working, there could be matters that come up beyond the pre-employment phase that involve substances, and Jennifer is going to discuss work-related accidents and the interplay with controlled substances.
Right. With regard to workers' compensation, intoxication is one of the few defenses that an employer actually has for a workers' compensation injury. We're going to discuss a little bit later about the post-accident drug testing. So how would you even know whether or not they were intoxicated? But we're going to talk about that a little bit later. First, we're just going to talk about Pennsylvania and New Jersey workers' compensation injuries and how they treat the intoxication defense. So the first situation is a Pennsylvania workers' compensation accident. And Pennsylvania Section 301A states that no compensation shall be paid when the injury or death is caused by the employee's violation of law. So this would include illegal drugs and how that impacts the claim. This is an affirmative defense, and as such, the burden of proof is on the employer, so it's important to note that. The evidence has to be clear and convincing. There would be witnesses that are credible if they distinctly remember the facts to which they testify to, and their statements are true. Proof beyond a reasonable doubt is not necessary. Also, Pennsylvania looks to whether or not there was a violation of law. So if there was a violation of law, either a misdemeanor or a felony, then compensation is not payable. So also keep in mind that a summary offense may be introduced into evidence to prove a violation of law. So it's important that when handling a Pennsylvania workers' comp case, that if there's been a violation of law, it's something you want to be aware of. While you wouldn't necessarily be involved in that aspect of the legal case, it's something that you want to keep in mind and keep up to date and abreast of the decision and whether or not there's actually a violation found ultimately by the court.
So Jen, in Pennsylvania, for violation of law, would the individual have to have been convicted or plead guilty versus just the charge? They would have to actually have been found to have violated the law.
Exactly. You'd have to wait until actually the decision has been made and there's either they plead guilty or they're found guilty. You can introduce the information about a summary offense, but that's not necessarily binding on the court. It would be that decision that it's either they're found guilty or they plead guilty. And with regard to the violation of law, the employer must prove that the violation of law was the cause in fact of the injury. So keep that in mind. And again, this is an affirmative defense. It can be used even when a violation of law doesn't occur. So just because there isn't a guilty verdict or they plead guilty, it's something that you can still introduce. However, the work injury must have occurred but for the intoxication of the employee. So, however, that but for can be defeated by expert testimony. So the employer's expert would be refuted by the toxicology reports. There's things that they would go into in defeating that but-for decision. So it's not necessarily a clear-cut decision when there hasn't been a violation of law. It's obviously easier when there is a violation of law, but just because there isn't a guilty verdict or they plead guilty, you can still pursue it. So it's something to keep in mind.
So that's in Pennsylvania, the but-for test. How about in the state of New Jersey? Is it as what I would refer to as employer friendly in New Jersey with regard to the intoxication defense as Pennsylvania is?
Right. New Jersey is, in my mind, the opposite of Pennsylvania. They really just don't want to give employers an opportunity to use intoxication as a defense. So while it is a defense, it's not something that I've never had it be successful. It's really just a very difficult burden for an employer to prove. The statute NJSA 34:15-7 states that the employer has the obligation to prove that intoxication is the sole cause for the accident. So it has to be the sole cause to avoid liability.
So that would mean it would have to be proven to be literally the only cause as the sole cause.
Exactly. And you'd have to prove this by a preponderance of the evidence. So it really just doesn't happen. And keep in mind, intoxication would include both drugs and alcohol. So it's not just, it would be both of those. And even if drugs or alcohol are involved in the injury, so you get a positive drug test after an accident, that doesn't mean that you're going to get out of it. It's extremely difficult because you have to prove that it's the sole cause, and that doesn't usually happen. So even if they're driving and they're drunk or they're have a illegal substance in their system and they get into a car accident, that still wouldn't be enough.
Or operating machinery, for example.
Exactly. It could be that the road conditions, it could be that they were distracted by something else. There's a multitude of other excuses, as I feel, and so the courts generally find a loophole and find that that it's not the sole cause.
So in addition to what can happen with regard to controlled substances and work-related injuries, and Jen will be talking some more about the post-accident setting, for example.
Right.
The issue of controlled substances could come up once an employee is obviously working for an employer that's not related to a job accident or on the job accident.
Right.
And there could be situations where either discipline or reasonable accommodations or both may come into play. So, for example, who may be entitled to a reasonable accommodation under the ADA when it comes to this topic? Well, as we talked about before, since an individual is recovered and not currently using illegal substances, such an individual, is covered and could possibly seek, or the employer may need to consider a reasonable accommodation. And again, this could be with regard to alcohol as well. So whether it's to attend a meeting for self-help or potentially maybe some leave of absence, the reasonable accommodation aspects of the ADA could come into play.
And you had mentioned before the treatment of methadone. So would that be considered a reasonable accommodation?
It could be. I mean, it may not necessarily play out to turn out to be a reasonable accommodation that the employer can provide, depending on what the person's job position is and essential functions and the type of business that it is and the operations. But to attend, for example, a meeting or some treatment could certainly be considered a reasonable accommodation under the ADA. So there could be situations where, and this is exclusive of a post-accident drug test, which would typically provide firm results that there was perhaps a controlled substance involved when the accident took place. But there could be situations that are not on the job accidents where maybe there's some suspicion of drug abuse in the workplace. So again, if it is illegal drug use, it is not protected under the ADA. So whatever the policy is about illegal drug use in the workplace can be applied and handled with the employee that way.
And making sure that this information is in your policies is the first step.
Yeah, if an employer has, and I mean, it's not required, but if an employer seeks to have a drug and alcohol policy, and we work with writing those kinds of policies or revising those kind of policies and handbooks, I think it's important to note that in addition to, if you're going to prohibit drinking or illegal use of drugs in the workplace, that policy should also state that illegal use of drugs includes unlawful use of prescription drugs.
Mm-hmm.
So what could be maybe some signs and symptoms? And not suggesting that just because some of these things may happen means that an individual has an abuse problem,
Right.
But sometimes these are the kinds of situations that arise, such as absenteeism, tardiness, or as you talked about, on-the-job accidents.
Mm-hmm.
So when we talk about whether rehabilitation is a shield, what we're talking about here has to do with the underlying conduct or misconduct, if you will, that an employee engaged in. So whether it was is it a violation of policy with regard to tardiness or excessive absenteeism, for example, or is it more, a conduct rule that was clearly, at play here, and that was violated by the individual. And if that individual then indicates that he or she has a problem, they were taking prescription medication and it made them behave that way, or something like that, or I have a problem, I have an addiction, then what the employer can do, and actually can still do, if you will, is still issue discipline for the underlying misconduct. So in other words, an individual who may be having those issues isn't provided with some sort of shield that he or she can't be disciplined. You're held to the same conduct and performance standards as all other employees. Sometimes if an employer has an EAP program, an employer may want to offer that as something for the employee to consider, but it's certainly not required under the ADA to provide that opportunity in lieu of discipline. An employer could also consider what's known as a last chance agreement. We prepare those, for example, where an individual is provided with a written agreement that they must sign that spells out, what their last chances are, if you will, before there may be some further action, including termination.
Okay. And going back and talking about some of the workers' compensation legal issues associated with drugs and alcohol, one of the more recent changes has been with the new OSHA regulations post-accident. And so the testing before, you could test post-accident anyone. Now there has to be a specific reason why you're testing them. So could drugs, alcohol, could intoxication have any impact or any cause for the accident? Again, in New Jersey, it's not really necessarily going to matter because it's really difficult to prove, but that's not always the case. So the other issue is that you could potentially, even though you can't get out of the workers' compensation case, if there's still an employment violation, that could be addressed separately. So it is important to keep in mind that your drug testing policies can't just be an absolute that post-accident you drug test. There have to be exceptions. So that new regulation is important. It's also another one of the issues is the payment of drugs. We know that the cost of opioids has skyrocketed, and so the payment of drugs as part of a workers' compensation claim generally increases the overall cost of these claims. So it's something you want to keep in mind. You also have the issue of return to work and whether or not when they're prescribed the opioids, can they actually return to work? Is that going to prevent you from your plan of trying to get them back to work as soon as possible?
And when it comes to the ADA, although that could be a whole other topic we could spend a webinar on, an issue could arise as to that individual's return to work. Can they perform the essential functions of the job with or without a reasonable accommodation? Now, if there's is a heavy medication involved like that, and is it a safety sensitive position, there might need to be some sort of assessment as to whether there's a threat to the safety of the employee or coworkers
Mhm.
as a result.
Absolutely. And most people who have handled workers' comp claims know that once you have opioid prescriptions, generally the claims become much longer, partially because obviously they're prescribed the medications, and then they have to go through a weaning process. So what could originally be a short-term claim ends up turning into a long-term claim. Um, Additionally, employee addiction is a major concern. So you have doctors who are prescribing these medications for short-term or long-term treatments. And a lot of times you get these even with minor injuries, which a lot of times they should just be prescribed an over-the-counter medication or a simple anti-inflammatory, and then they're prescribed these heavy opioids. It really is concern. Um, you have to keep in mind that a lot of the employees, if they have the control of their treatment, they may go from doctor to doctor until they find a doctor who's willing to prescribe them the medication that they want to take. You also have where legal medications turn into a gateway drug to illegal prescriptions. So some of these people we've heard constantly in the news that you have someone who was either a work accident or even a sports injury or things like that, that it becomes a great way gateway drug to them then turning and using ultimately illegal prescriptions due to their addiction. So it's a major concern. And pain relievers that the doctors are using can include oxycodone, hydrocodone, morphine. Prescriptions have drastically increased over the last few years. And in workers' compensation claims, we know that over 30% of work-related injuries are being treated with opioids. So it's really just a concern and a problem. Um, the FDA has started to put black box warnings on the medications. The CDC has created guidelines to encourage the doctors to try other forms of treatment. And then you also have occupational health providers who are trying early intervention therapy. So trying to avoid that narcotic medication through this type of therapy rather than using those medications. Fortunately, in New Jersey and Pennsylvania, we both in both those states, there's drug monitoring programs and databases. The doctors can go on and can check. In New Jersey, it's the NJPMP, the New Jersey Prescription Monitoring Program, and in Pennsylvania, it's the Pennsylvania Prescription Drug Monitoring Program, PDNP, and the doctors can go on and check to make sure whether or not their patients are being prescribed a medication already and making sure that there's no overprescription. For New Jersey, we get to control medical treatment in workers' compensation claims, so it's important for you to use a doctor who checks the databases or making sure that the doctors that you're using have a conservative prescription history. In Pennsylvania, you control the medical treatment for 90 days. So the carriers can pick those doctors initially who help control the medical and the opioid prescriptions. But after the 90 days, it's important that you check the bills and the records to see if there's any overprescription problems. And you can bring that to the attention of the attorneys handling the cases. So the carriers really should be getting involved in making sure that this isn't a problem in the case. And if it is, trying to find a way to correct the problem.
So in New Jersey, it's not just after the first 90 days.
No, we control the treatment the entire time. Yeah. So we have a little bit more control over the doctors and making sure that those doctors that we're using are actually prescribing medications cautiously.
Okay, well, this is a topic that we could spend a lot more time on, and we're certainly available. So thank you for attending our webinar, Substance Abuse in the Workplace. If you have any questions about today's presentation, please email us at questions@wglaw.com. You can learn more about this program, as well as all other Weber Gallagher events, by visiting the website www.wglaw.com/WG-University. Thank you for joining us today.
Thank you.